This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a sexual assault was excluded and why, regardless of the arguments of the injured person, the situs of an assault does not create coverage under an auto liability policy. And just because you're assaulted on a school bus does not provide coverage under the school bus's liability coverage. The coverage dispute arose from the sexual assault of a special needs student aboard her school bus. National Liability and Fire Company sought a declaration that it had no duty to defend or indemnify the bus company or its school district client in a state court action brought by the student and her mother because of its policy did not cover the incident alleged in their complaint. The district court erroneously held that National had to defend both entities and later concluded it had to indemnify them. In National Liability and Fire versus Brimar Transit, the United States Court of Appeal for the Third Circuit on September 22, 2023 resolved the dispute. Brimar Transit, Inc. transported students for the Pittsburgh School District under a multi-year contract. National insured the vehicles in Brimar's fleet. Among the students Brimar transported to and from school were children with special needs. One of these students, an adolescent girl named KM, had developmental challenges known to Brimar and the district. Traveling on the bus with her each day was a 12-year-old boy with similar challenges who had sexually assaulted KM multiple times, including a groping incident during gym class. The gym incident led the district and Brimar to craft a special plan to separate KM from the male student on the bus. KM sat behind the driver while the male student sat in the rear. The regular bus driver followed the plan, and when she took maternity leave, her first replacement did so as well. A second substitute driver took over the route without following the plan and sat KM next to the male student. Their proximity allowed the male student to use his body weight to pin KM to the seat, and with KM trapped, the male student pulled down both their pants and assaulted her from behind. Despite being only several feet away during the assault, and despite the cries of the other children, the driver did not intervene or even acknowledge the attack on KM. KM managed to push the male student off her a short time later, though he assaulted her again by slapping her backside as she exited at her stop. KM and her mother sued Brimar and the district, alleging Brimar failed to tell the driver about the plan and failed to train and supervise her properly. They similarly alleged the district was negligent and should have ensured KM's safety on the bus. National defended Brimar in the state court action after issuing a reservation of rights letter, but declined to defend the district. National sued, seeking declaratory judgment, and later moved for judgment on the pleadings, urging that it had no duty to defend the defendants for two reasons. First, it had no duty to defend Brimar because KM's alleged injuries did not result from the use of the bus, and there was an abuse and molestation exclusion that should apply. Second, it had no duty to defend the district as a non-insured. The district court disagreed with National on both counts, and while the action was pending, National paid more than $500,000 to settle the plaintiff's suit. National moved for summary judgment, yet the trial court held that because National's act of settling the state court claim before critical facts and evidence developed kept the district court from making nuanced decisions about its duties to defend and indemnify, it would need to indemnify Brimar in the district. Pennsylvania law imposes separate though related duties on insurers to defend and indemnify their insureds. Pennsylvania courts analyze those allegations using the Four Corners rule. If the allegations even potentially could support recovery under the policy, then the insurer has a duty to defend its insured in the case. Therefore, the policy determines whether National had a duty to defend, and based on that provision, National offers two ways in which the district court erred in holding it had a duty to defend. First, the complaint pleads injuries resulting from the sexual assault, not the use of Brimar's bus. And sexual assaults like KM's are excluded by the policy's abuse and molestation exclusion. National argued the district court erred and urged instead that to trigger coverage, the underlying bodily injury must be causally connected to the use of the insured vehicle as a motor vehicle. The male student's previous assaults confirmed the bus was merely incidental to the sexual assault, that is, as the situs of the attack. Because the allegations in the complaint do not forge a strong enough link between the use of the school bus and KM's injuries, the Third Circuit concluded that the district court erred in finding National had a duty to defend Brimar and the district, and sent the case back to the district court to rule in favor of the insurer. In my opinion, the injuries suffered by KM were horrific, but they were not, under any definition of the term, a result of the use of the school bus. The driver erred, but the driver, not the use of the bus, caused her injury. National should now seek to recover the money it paid under the reservation on behalf of the defendants and obtain reimbursement of the full $500,000 it spent to settle the case in an expression of absolute good faith. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog, and you can subscribe for free and receive notice of all blog postings, usually 5, sometimes 6 a week, and access to all 4,600 or more blog postings. If you found this video to be useful, please tell your friends and colleagues about the blog and the videos and let them also subscribe. And if you are interested in obtaining further information or detail about insurance, insurance law, insurance claims, and insurance fraud, please consider, for a very small fee, subscribing to Excellence in Claims Handling at substack.com and or to my locals community. Thank you for your attention.